Hi everyone. Today's unit that we'll be doing is legal research methods, and my name is Shazia Khan. The unit number is L6187921, and the first learning outcome we'll be doing is learning outcome 1, which is to understand how to conduct legal research. Now, any sort of research towards doing any sort of legal research is really important. You know, it's there where you are trying to find answers to some sort of legal decision or an argument. So it's really important whenever, you know, someone stands up in courts and tries to research a case, they need to be able to support that case with decided previously cases and already the statute that's in place as well. So it's really important when it comes to legal research. So the unit aim is to allow learners to develop any sort of key knowledge, understanding and skills relating to legal research and theoretical and methodological problems associated with legal studies. So the learners will be able to cover key topics relating to a research problem, conducting any sort of literature review, which we'll be going through in the other learning outcomes as well, referencing, so using the Harvard system for referencing, data collection and analysis, techniques and drawing conclusions from analysed data. So learning outcome 1, the indicative content for learning outcome 1 is we'll be looking at the doctoral research. So research in the law, jury, we'll be looking at issues and criteria to conduct a legal research, social legal studies, so exploring decision-making of magistrates and juries, ethical dimensions, we'll be looking at the black letter, which is actually focusing on case law, statutes and other legal sources, a pure doctrinal approach, makes no attempt to look at the effect of the law or how it is applied, but instead examines the law and as a written body of principles which can be discerned. So we're going to be looking at the black letter and focusing on case law and statute. Key terminology when we're looking at learning outcome 1. The first one is legal research. So this systematic process of identifying, like I mentioned, analysing, interpreting legal sources to address a specific legal question or issues. So anything to do, for example, if you're looking at any sort of legal research around employment law, the changes, you'd refer to the law around its statutes and any sort of previously existing cases that are similar to the cases that you are researching. Number 2, criteria for legal research. So the essential standards or requirements for conducting effective legal research, including clarity of research objectives, thoroughness of research, relevance of sources, accuracy of analysis and effectiveness of the communication. Number 3, key issues. So significant aspects or topics within legal research that require investigation or analysis, such as access to information, interpretation of legal sources, synthesis of legal principles, and application of law to specific scenarios. We'll be also looking at number 4, which is socio-legal studies. So interdisciplinary field that examines the relationship between law and society, focusing on how legal rules are created, interpreted, and applied with social contexts. So we'll also be looking at number 5, which is research methods. So the techniques or procedures used to collect, analyze, and interpret data in a legal research, including qualitative methods, for example, interviews, observations, or quantitative methods such as survey, statistical analysis. We'll also be looking at ethical dimensions, so moral considerations and principles that guide the conduct of legal research, including integrity, honesty, respect for participants, confidentiality, avoidance of harm, and fair representation. We'll also be looking at number 7, which is the black letter approach, as I mentioned earlier, a traditional method of legal research that focuses on studying established legal principles and rules derived from judicial decisions, statutes, regulations, and legal treaties. Number 8, doctrinal research. Legal research method that involves analysis of legal rules, principles, and the doctrines through the study of legal texts, precedents, and commentary. And number 9, finally, which is an informed consent, so voluntary agreement by research participants to participate in a study after being informed about the nature, purpose, risks, and benefits of the research. And then this video we've got here that you can watch in your own time is on the legal research strategy, and it's by the Harvard Law Library. So it shows you the elements and the strategies around legal research. So we're going to go on to an introduction first. So introduction to legal research. Legal research serves as a cornerstone within the realm of legal studies and professional practice. It embodies a systematic inquiry process aimed at identifying, as we mentioned earlier, assessing, analysing, and interpreting legal sources. These sources include statutes, case law, regulations, legal treaties, and scholarly articles. Through the process of legal research, individuals seek to comprehend the intricacies of law, unravel legal complexities, and derive meaningful insights that contribute to informed decision-making and problem-solving within legal frameworks. Legal research literally means finding answers, as we mentioned earlier, in the law to support a legal decision or argument. Whenever a solicitor or barrister makes a statement in court, they must support it with law or previously decided cases. If a law already exists or a case which is decided in a particular way, other cases must follow. As we mentioned, there are different types of sources that can be used. So we could have primary or binding law, which is codified, as we mentioned, in statutes, regulations, codes, treaties, and case law. And then we'll also have secondary sources which explain things like, articles, journals, legal treaties, annotations. And we have also non-legal supplementary sources such as investigative articles, news reports, blogs, and other material can support any sort of legal advice in some areas. When any sort of legal professional takes a case on, they begin by researching any sort of secondary sources to see what might apply to the facts of the case. For instance, if you have a dispute, an example would be like a real estate dispute over property lines. They may have to review property disputes. They may have to review how property disputes have been handled in that kind of jurisdiction, because different countries have other agencies and different countries have different jurisdictions. So they really need to be careful when they're researching that it applies to the law of that country. Importance in academic and professional context. The significance of legal research transcends academic boundaries, permeating various professional domains and societal contexts. Within academic spheres, legal research forms a bedrock of rigorous scholarly inquiry, fostering critical thinking. So, the way you think, it needs to be really important. Analytical reasoning, so analysing, and intellectual engagement among students and academics. It equips them with the requisite skills to navigate legal landscapes, engage in scholarly discourse, and advance knowledge with their respective fields of study. In professional realms, legal research assumes paramount importance for legal practitioners, including lawyers, judges, and legal advisors. It empowers them to interpret, as we mentioned, analyze, and apply the legal principles in a variety of diverse legal scenarios, things like litigation, criminal law, property, as we mentioned. Moreover, legal research underpins evidence-based decision-making and policy development, enabling policymakers to actually craft the legislation, regulations, and public policies in line with legal norms, societal values, and public interest. So, for example, I'll give you the example. There was a need for the law relating to mobile phones. So the law was passed that if you were using a mobile phone whilst driving, you would get a fine and penalties. And there was a need for that due to societal change, where there were lots of accidents that were occurring whilst people were on the mobile phones. Also, legal research is mainly the activity that identifies the information to strengthen any sort of contract or any sort of brief or document. The whole process begins, as we mentioned, with extracting facts from a wide range of sources, analysing, interpreting the facts, and then applying them. And that starts the whole process off. So the foundation of a strong, watertight case depends largely on his exercise, making it important for lawyers in general to research what they are doing. The importance, again, of legal research cannot be overstated, as it helps lawyers and solicitors find the most relevant and persuasive authorities, arguments, and precedents for their cases. It also requires special skills to maintain high standards of research. Lawyers do not derive their strength from their knowledge of the law, but rather their ability to research the relevant sectors, bringing in tune with the requirements. Things like going on to free legal websites, legal research environments, chronicles, law libraries. There's a variety of sources, that they could use, journal, books. It's really important when we look at legal research that, we are precise and accurate when we follow the law. Because moving away from that, if you're researching something on property law, you need to be looking at property law journals. You need to be looking at resources on property law, and researching that, not researching something on criminal law or personal injury. So you need to make sure that it's precise and accurate, and it's easily, that the lawyers can, reinforce what they are saying to, justify their argument. It is the bedrock of everything research, and it is the core of the core activity that lawyers will focus on when they are going to court, because they have to present their argument in a very efficient way. So the criteria for conducting legal research. So definition of legal research, as we said earlier as well, legal research epitomizes a methodological and rigorous process essential for navigating the complexities of legal frameworks. It encompasses a systematic inquiry aimed at identifying, accessing, analysing, and interpreting a myriad of legal sources, including, again, statutes, case law, regulations, legal treaties, and scholarly articles. This process enables individuals to delve into the intricacies of the law, elucidate legal principles, and derive insights that facilitate informed decision-making and problem-solving with legal context. While in any sort of research, the techniques and tools may vary, the goal of legal research is simple. You want to find the relevant information and resources, for example, the law that apply to the facts of the case, so that you can support legal decision-making. Legal research processes can be broken, as we mentioned earlier, into 3 elements: understanding the key details, finding laws, and achieve your research goals. It's really important that you achieve what you are there to do. So effective identification of criteria for effective legal research. So effective legal research is predicted on adherence to specific criteria that ensure the robustness and validity of the research outcomes. These research serve as a guiding principle that underpin the research process and contribute to its efficiency. Key criteria include, number 1, clarity of research objectives. So a clear articulation of research objectives is paramount to delineate the scope and purpose of the research endeavour. Defined objectives provide a roadmap for conducting focused and purpose-driven research, guiding researchers towards relevant legal sources and pertinent analysis. So you need to make sure that your objectives actually define what you are doing. Okay, so a clear clarity of your research objectives, what you aim to do, or your objectives are. It's like a map for your guidance for where you're going to go towards doing the analysis, and you need to be clear on that at the start when you're starting this research. Number 2, thoroughness of the research. So thoroughness entails comprehensive exploration and examination of the pertinent legal sources to gain a holistic understanding of the legal issues at hand. It necessitates diligent inquiry into relevant statutes, case law, regulations, and secondary sources to ensure that all relevant perspectives and authorities are considered. Number 3, the relevance of the sources. The selection of relevant and authoritative sources is imperative to the credibility and reliability of legal research. Researchers must discern between primary and secondary sources, as we mentioned earlier, assess their relevance to the research topic, and prioritize any sort of sources that provide authoritative guidance and legal precedent. So important. This is one of the main elements of your research project, and it is your sources, because your sources will be the sources have to be credible. They have to be the research that applies to your research project, and you need to make sure that you are prioritizing the research you're using and they're authentic. Things like, sources. Wikipedia is something you wouldn't use because people can add to it, but authentic sources could be like gov.uk, where you could actually, refer to that source, or any sort of England law reports, or family law journals, if it's a family law area. So it depends on what you do your area on. The resources need to be credible. Number 4, the accuracy of analysis. So accurate analysis entails the application of sound legal reasoning and critical thinking skills to interpret and evaluate legal sources effectively. Researchers must employ analytical methodologies that are robust, objective, and logically coherent, ensuring the validity and integrity of the research findings. Number 5 is effectiveness of communication. Now, effective communication encompasses the articulation and dissemination of research findings in a clear, concise, and persuasive manner. Researchers must convey their insights and conclusions coherently, tailoring their communication to suit diverse audience and stakeholders within legal and non-legal domains. So you need to make sure that you are reaching out for the audience that you need to reach out for. So, you need to make sure that you are tailoring your communication towards a diverse audience. So it could be people from the legal sector. It could not be people from the legal sector. So you need to make sure that when you are doing you are communicating to them, you are doing your research that is clear and concise to what kind of area of audience you portray your research to. So key issues in legal research: definition and identification of key issues. So key issues in legal research encapsulate fundamental areas of inquiry that shape the research process and inform the analysis of legal phenomena. These issues span a spectrum of complexities within legal frameworks, encompassing things like, so key aspects are, number 1, access to legal information. And the description is researchers must access various repositories of legal information, including online databases, libraries, archival records to find statutes, case law, regulations, and commentaries. And these are authentic sources that you need to be using to get any sort of legal information and research these as well. Number 2, interpretation of legal sources. Researchers interpret legal principles, rules, and doctrines found in statutes, case law, and other legal materials. They analyze judicial opinions, statutory provisions, and legal commentary to understand the intent, meaning, and application of legal norms. Number 3, synthesis of legal principles. Researchers identified common themes, principles, and trends across different legal sources to distill coherent frameworks and conceptual models. They synthesize legal doctrines, precedents, and scholarly discourse to discern underlying principles governing legal reasoning and decision-making. Number 4, application of law to specific scenarios. So researchers apply legal rules, doctrines, and principles of specific factual situations to determine rights, liabilities, and legal remedies. They analyse cases, interpret statutes, and present legal arguments to derive to a conclusions and recommendations suited to unique factual contexts. Importance of identifying key issues in your research. So it's really important for you as an individual to identify key issues in your research when looking at research in these areas. So focusing efforts. So clarifying key issues enables researchers to concentrate their efforts and resources on areas of substantive legal significance, avoiding unnecessary diversion of resources on the peripheral issues. For example, if you're doing a research paper on the fusion between barristers and solicitors and why there's a need to have one academic body rather than having solicitor and a barrister, you would look at just identifying that area rather than looking at criminal law or rather than going into looking at property law. You would identify and concentrate on the fusion between barristers, what they do, rather than moving away from that area. Prioritizing resources. So identification of key issues facilitates efficient resource allocation, allowing researchers to allocate time, funding, and expertise towards addressing critical legal questions that have practical implications and societal relevance. Formulating research questions. So key issues inform the formulation of research questions that encapsulate the core objectives and inquiries of the research endeavour. Articulating precise research questions guides the research process and facilitates targeted inquiry into specific legal domains. Diversity of research methods in socio-legal studies. Overview of socio-legal studies. So socio-legal studies represent an interdisciplinary field that delves into the intricate interplay between law and society, elucidating how legal rules, institutions, and processes intersect with social dynamics, norms, and practices. At its core, social legal studies scrutinize the multifaceted relationship between law and society, exploring the ways in which legal norms are shaped, interpreted, and operationalized with diverse social contexts. By examining the social dimensions of law, social legal scholars seek to unravel the complex interactions between legal systems, socio-cultural forces, and institutional practices, shedding light on the broader societal implications of legal norms and regulations. Exploration of research methods used. So research methods employed in social legal studies encompass a diverse array of qualitative and quantitative approaches tailored to capture the complexity and nuances of legal phenomena within any sort of social context. These methods are categorized by their versatility, flexibility, and interdisciplinary orientation, enabling researchers to adopt multifaceted strategies to investigate legal issues. Key research methods utilized in social legal studies include, firstly, we're going to look at qualitative methods, and these are methods that are mainly understood by social scientists who often understand how individuals think, feel, or behave in a particular situation, or in relation to others that develop over time. They use an in-depth, interviews, participate, observation, and other qualitative methods to gather data. Researchers might watch, an example might be that researchers might watch a school playground to observe and record bullying behaviours, or ask young people about exactly what they understand by being bullied and how they thought it affected them. Qualitative research methods provide rich, nuanced insights into the social dimensions of law, emphasizing into exploration and interpretation of the social phenomena. So qualitative methods are scientific, as we mentioned, but are focused more on the meaning of the different aspects of people's lives and on their accounts of how they understand their own behaviour and beliefs. case studies where researchers examine a small number of specific examples and narratives where researchers study respondents' stories in depth are just two examples of methods used in qualitative research. So some of these are the methods used here, which we've looked at. Interviews, which are conducting structured or semi-structured interviews with legal actors, stakeholders and community members to elicit their perspectives, experience and understanding of any sort of legal issues. So they would prepare questionnaires in regards to that, or ask questions around that. Observations, engaging in participant observation or ethnographic fieldwork to observe and document legal practices, behaviours and interactions within specific social settings or institutions. Case studies, so analysing different individuals' cases or legal disputes to examine the intricate dynamics of legal decision-making, dispute resolution processes and outcomes. So in regards to the interviews, you could have semi-structured interviews, or you could have unstructured interviews, and semi-structured interviews are literally where the researcher has a small core of questions or areas they wish to explore, but will then take the questions in different directions depending on the answers they receive. In this one, flexibility is important with this type of issue, and this method is used when seeking richly descriptive information. For example, if you're looking at things like what makes a good teacher, that could be an example of a semi-structured interview, whereas when you have an unstructured interviews, they are open-ended and they are informal. So this is where the researcher is actually seeking a detailed picture and tries to have no preconceptions. So this type of interview is often used in a narrative research. Generally, the researcher asks one question, then leaves the interviewee to talk or tell their story. So it's really important in regards to that. Observations relies heavily on skills of the researcher to understand and interpret what they are seeing in an unbiased way. So here, there's no use of having bias towards anything. It has to be in an unbiased way. It might be used, for example, in educational research to see how much time young people spend on a task and what they do when they are distracted. In this method, the researcher observes what is happening and makes field notes either at the time or soon afterwards. Another survey that could be used in case studies we mentioned, analysing individual cases, identifying the importance of these cases and trying to, pull out the legal elements of these cases. Case studies work really well with some forms of research. Quantitative methods. So quantitative methods, research methods employ statistical techniques to analyse numerical data and patterns, enabling researchers to quantify and measure social phenomena. Examples of quantitative research include surveys and statistical analysis. So these are things like numerical data. Quantitative data analysis employs statistical techniques for processing and interpreting numerical data, as we mentioned. Research designs in the quantitative realm outline how data will be collected and analysed with methods like experiments and surveys. Qualitative methods complement quantitative research by focusing on numerical data, adding depth to understanding, data collections. So an example of, as we mentioned on the slides, is an example of a quantitative research study is the survey conducted to understand, for example, how long a doctor takes to tend to a patient when the patient actually walks into the hospital. So, how long the doctor would take. So a patient, in this case, they would do a patient satisfaction survey, which can be administered to ask questions like how long a doctor takes to see a patient, how often a patient walks into a hospital, and other such questions which are dependent on variables in the research. This kind of research method is often employed in the social sciences and involves using mathematical frameworks and theories to effectively present data, ensuring that the results are logical, statistically sound, and unbiased. Statistical analysis, so it's employing statistical tools and techniques such as regression analysis, correlation analysis, and multivariate analysis to analyze quantitative data and identify patterns, trends, and relationships with legal contexts. Data collection in quantitative research uses a structured method and is typically conducted on larger samples, representing the entire population. Researchers use quantitative methods to collect numerical data, which I mentioned earlier as well, which is then subject to statistical analysis to determine statistically significant findings. This approach is valuable in both experimental research and social research, as it helps making informed decisions and drawing reliable conclusions based on quantitative data. Examples of research methods in social legal studies. So social legal studies, scholars leverage a diverse array of research methods to investigate legal phenomena within social contexts, tailoring their methodological approaches to the specific research questions and objectives. Examples of research methods employed in social legal studies include ethnographic research, which is immersing oneself in the field to observe, document, and analyze legal practices, rituals, and interactions within specific social and cultural minors. Ethnography was popularized by anthropology, but is used across a wide range of social sciences. Within the field of usability, user-centered design and service design, ethnographic is used to support a designer's deeper understanding of the design, including the relevant domain, audience, processes, or contexts and goals that they will use. Ethnographic is recommended to be used for very complex or critical design thinking problems, and there, for example, an example of an ethnographic research would be an insurance company, for example, wanted to redesign their system dealing with the processing of insurance claims. This system had evolved over many years and actually represented a patchwork of previous systems. The claim processing supported by this system of systems is itself a highly complex process. In this example, the ethnographic research should probably be considered. The next is comparative legal analysis. So comparing legal systems, institutions, and practices across different jurisdictions or historical periods to identify similarities, differences, and patterns in legal development and the implementation. As the world has become smaller through the effects of globalization, scholarship in comparative law has expanded. The scholarly study of the similarities between the different jurisdictions looks at the comparison between their laws, the laws, the statutes, the effects of any sort of patterns within their legal system. A comparison between the civil law system of Quebec and the common law system of Ontario would be the realm of comparative. So where you're comparing the law is really important to identify certain elements and identify similarities or differences that would help you, identify, come to a comparative analysis. Content analysis is a systematically analyzing legal text, documents, and media representations to discern prevailing discourses, narratives, and ideologies surrounding the legal issues. Social scientists use content analysis to examine patterns in communication in a replicable and systematic manner. One of the key advantages of using content analysis is to analyze social phenomena is their non-invasive nature, in contrast to simulating social experiences or collecting survey answers. Practices and philosophies of content analysis vary between academic disciplines. They all involve systematic reading or observation of texts or artifacts which are assigned labels to indicate the presence of interesting, meaningful pieces of context. By systematically labeling the content of a set of texts, researchers can analyze patterns of content quantitatively using statistic methods or using qualitative methods to analyze meanings or content within text. Computers are increasingly used in content analysis to automate the labeling or coding of documents. Simple computational techniques can provide descriptive data such as word frequencies and document lengths. The next one and the final one is critical legal studies. This is engaging in critical examination and deconstruction of legal norms, ideologies, and power structures to uncover underlying social, economic, and political dynamics shaping the legal systems and practices. And this study is a school of critical theory, and it was developed in the United States during the 1970s. And the critical legal studies adherents claim that laws are devised to maintain the status quo of society and thereby codify its biases against marginal groups. Now we're going to be looking at the black letter approach to the doctrinal research, legal research. So explanation of the black letter approach. The black letter approach represents a traditional and foundational method employed in doctoral legal research, rooted in historical legal scholarship. The black letter approach actually focuses on the examination, analysis of primary legal sources, including case law, statutes, regulations, and legal treaties, named for the distinctively bold and legible typefaces used in early legal manuscripts. The black letter approach prioritizes the study of established legal principles and rules derived from the authoritative legal issues. And the black letter research methods is probably the most basic legal method, which relies on the doctoral attitude in the study of law in a substantive manner. As we mentioned, it's a rigid research method which researchers follow certain established processes, often characterized, as we mentioned, for both primary and secondary sources. The term black letter signifies this inflexibility in the description of legal matters, categorized the basic standards, policies, and principles of a particular area of law. So focus on case law, statutes, and legal sources. Central to the black letter approach is an emphasis on the study of case law, statutes, and other formal legal sources that serve as pillars of legal authority. Researchers engaged in black letter research meticulously analyze judicial decisions and statutory provisions to discern prevailing legal norms, doctrines, and principles governing specific areas of law. By focusing on primary legal sources, black letter research aims to elucidate the bedrock principles underlying legal doctrine and jurisprudence. This, therefore, actually means that the traditional black letter researchers will look into existing legal precedent that is recognizable in case law and continually examine the content and the aim of establishing the reasoning behind a legal opinion and the implication of such opinion or decision on future legal issues. Other forms of sources of information, such as authorial observations, are considered secondary in research and would focus on sources such as legal journals, texts, and articles, where these actually sources seek to explain the law to those that to prove vital research and gain any sort of other areas of specific legal research. Characteristics of the black letter approach. So firstly, they focus on formal legal sources. As we mentioned, the black letter approach prioritizes the study of formal legal sources, including written opinions of courts, legislative enactments, and authoritative legal commentary. By confining its inquiry into established legal materials, the black letter approach seeks to identify and interpret legal rules and principles with actually precision and clarity. The next characteristic is number 2, which is textual and historical analysis. Black letter research involves a meticulous examination of legal texts and historical precedents to trace the evolution of legal doctrines over time. Researchers engage in textual analysis to decipher the meaning and intent of the legal provisions, while also delving into historical context to understand the origins and development of legal principles. Features of doctrinal research. Doctrinal research constitutes a foundational methodology with legal scholarships, categorized by its focus on the analysis and interpretation of legal rules, principles, and doctrines through the systematic study of legal texts and precedents. Rooted in the tradition of legal positivism, doctrinal research emphasizes the application of formal legal sources such as statutes, case law, regulations, and legal commentaries to elucidate legal norms and principles governing specific areas of law. Doctrinal research is based, as we said, on secondary sources of information like articles, commentaries, textbooks, etc., but non-doctoral research is based on primary sources like surveys and case studies. According to Professor S.N. Jain, doctrinal research involves analysis of case law, arranging, ordering, and systematizing legal propositions and study of legal institutions through legal reasoning or rational deduction. It is it differs from other methodologies in that it looks at the law itself. Within itself, a pure doctrinal approach makes no attempt to look at the effect of the law or how it is applied, but instead examines the law as a written body of principles which can be discerned and analysed using only legal sources. Doctrinal research, legal research is knowledge-based research in law rather than research about law. Judges, lawyers, academias, all are engaged in this kind of research. The actual purpose of doctoral research is to construct new legal theories, principles, and doctrines to test them and add new knowledge in the legal scholarship. It's also there to, one of the other purposes is to maintain continuity, consistency, and certainty of law, to resolve day-to-day client matters as it's more manageable and outcomes are more predictable due to its focus on established sources, to advise courts or clients, to critically examine the judicial opinions. And it's also there to provide lawyers and judges and others with the tools needed to reach decisions on immense variety of problems. It's there to develop any sort of theory that tries to explain how the law or areas of law fit together. And it's there to conduct comparative historical inquiries describing an earlier era or contrasting legal regime. And it's there to, expose tensions within practices or institutions. So it's really important, the exploration in regards to doctrinal research. So exploration of legal research methods. So methods employed in doctoral research encompasses a diverse array of analytical techniques tailored to integrate legal texts, discern underlying legal principles, and derive authoritative interpretations of legal rules. Common research methods utilized in doctoral research includes number 1, case studies. engaging in detailed examination analysis of judicial decisions to identify legal issues, interpret legal doctrines, ascertain judicial reasoning and underlying legal outcomes. Number 2, statutory interpretation, so systematically analysing legislative enactments and statutory provisions to interpret the meaning, scope and application of statutory law within specific factual contexts. Examples of doctoral research in practice. So doctoral research finds application across a broad spectrum of legal domains and scholarly inquiries, with examples spanning various areas of legal scholarship and practice. Examples of doctoral research in practice include studies of judicial reasoning, analysing judicial opinions and legal precedents to discern patterns of judicial reasoning, legal argumentation and imperative methodologies employed by courts in resolving legal disputes, investigations of legislative intent, examining legislative history, debates and committee reports to discern legislative intent and interpret statutory provisions within their legislative context, comparative legal studies, so conducting comparative analysis of legal systems, legal cultures, and the legal institutions to assess the impact of legal norms and practices on social, economic, and political dynamics within different jurisdictions. So different laws would apply in different jurisdictions, so that, you know, in regards to the law in America would be different to the law in the UK. You know, there would be some comparison between that. Doctrine developments in specific areas of law, so tracking doctrinal developments and paradigm shifts within specific areas of law, such as constitutional law, contract law, tort law, and criminal law, to understaff legal principles and doctrines over time. When we look at doctrinal research, it focuses on case law, as we mentioned, statutes and other legal sources, and it's there to help lawyers and academias to research these areas in regards to identifying what knowledge-based research is in law. Some of the characteristics are that it's doctrinal research is legal propositions-based study. As we mentioned earlier as well, it's a conventional theory, legal theory, statutory materials and court decisions report are the sources for doctrinal legal research. It studies the law as it exists. So I'm not concerned about how it should be, or even do not seek public opinion about how it should be. And doctrinal research is in law. It is research in law, not research about the law. So that needs to be really important in regards to identifying that. And it's distinguished from literature review, content analysis, or historical research, and the bulk of the research is the product of its approach. Now concluding in regards to learning outcome 1, in conclusion, the exploration of legal research methodologies, including the black letter approach and doctrinal research, underscores the multidimensional nature of legal inquiry. Through the black letter approach, scholars focus on traditional legal sources to derive authoritative interpretations of legal principles, emphasizing textual analysis and historical precedents. Similarly, doctrinal research provides a systematic framework for analysing legal rules and doctrines through the examination of legal texts and precedents, facilitating insights into judicial reasoning, legislative intent and doctrinal developments across various legal domains. By embracing diverse research methods, including qualitative and quantitative approaches, social legal studies illuminate the intersection of the law and society, offering insights into legal phenomena and their broader societal implications. Thus, the integration of these methodologies enriches legal scholarship, informs legal practice, and advances our understanding of complex dynamics shaping contemporary legal systems, and looking at the importance of legal research within a research project. So now we've finished learning outcome 1 in regards to the legal research methods unit. The next learning outcome will be learning outcome 2 in regards to the research methods. These are the references that have been used for today's session, which are listed in regards to helping you in regards to completing the assignments. So some of the references are just all there listed. In regards to referring to ebooks and journals on Moodle, there is some additional reading that you could go onto Moodle and which will help you look at the importance of legal research, and also any sort of additional information would be on Moodle. If you have any questions or any queries in regards to this unit, please email learnerwork@ukvarsity.co.uk. And when it comes to submission of your assignment, which would be done once this module is, this unit is completed, you would submit your assignment 2 weeks after the completion of the unit, and you would submit it to learnerwork@ukvarsity.co.uk. Thank you for attending this session, and this is the end of Learning Outcome 1, and I will see you in the next session, which is Learning Outcome 2. Thank you.